Good evening, everyone. My name is Natalie Klein, and I'm the Dean of Macquarie Law School, and it's an absolute pleasure to be able to welcome you all here this evening for the fourth Tony Blackshield lecture. We have a number of special guests here this evening, most importantly, of course, Emeritus Professor Tony Blackshield and his wife Rosemary Huisman, Emeritus Professor Gillian Triggs, the Honourable Justice Brian Preston, and Judith Preston as well, who could be sitting in the front with Brian, the Honourable Michael Kirby, and also the Honourable Helen Sham-Ho, Mr. Stuart Clark, Professor David Wilkinson, and Professor Martina Mollering. And also I'd like to welcome the newly elected members of the Melb Executive who are here this evening. I'd like to thank you all very much for attending this evening's proceedings. I'd also like to begin by paying my respects to the Gadigal people, who are the traditional custodians of this land where we stand tonight. And I'd like to pay my respects to their elders, both past and present, of the Eora Nation, and extend that respect to any other Aboriginal people who are here this evening. So now please let me introduce our Deputy Vice-Chancellor of Corporate Engagement and Advancement, Professor David Wilkinson, to do a welcome address and also introduce our speakers. Thank you.
Natalie, thank you very much indeed, and distinguished guests, ladies and gentlemen, good evening. It's my very great pleasure to be your host for tonight's Tony Blackshield lecture and alumni reception to welcome all of you here tonight. The Macquarie Law School has come a long way since it was first established over 40 years ago. When the law school began, it was something of an upstart. It was very disruptive by its very existence, a little bit like Macquarie University itself. And this history, of course, continues to enrich the school's identity today. The Blackshield lecture provides all members of the Macquarie Law School community, whether that's students, staff, graduates and friends, an opportunity to reflect on the power of the law and how it can be shaped in different ways. The Macquarie Law School, through you and your fellow alumni, is very much a player in the national and indeed international law scene now, with over 8,000 alumni worldwide. By way of background, and noting that some of these illustrious alumni are in the audience tonight, the law school alumni community includes 3 out of 5 of the chief judges in the New South Wales Judiciary, the New South Wales and Commonwealth Director of Public Prosecutions, the incoming President of the Law Council of Australia, and numerous eminent partners at national law firms and distinguished luminaries across many fields of human endeavour. It's fair to say that Macquarie Law School has well and truly arrived. So when the Macquarie Law School community comes together for the Blackshield lecture, this is a signature moment for graduates to help reconnect with the law school and with each other, as well as engaging with current staff and students. And we really do want you to take justifiable pride in your law school and help us in the university more broadly to spread the good word. But first to our history and our essence. What is it that makes the law school so special at Macquarie? Again, we think we know something of the answer. It's very interesting for me as a physician that when I ask this question of alumni, students, and in some ways, more importantly, those that employ alumni, I keep being told the same thing. They tell me it's not so much what you're taught or were taught at Macquarie, but how it was taught. This speaks, I think, to the calibre of the staff and the former staff that are here tonight, and I think speaks to the culture of the school and is very important. And it allows me to then turn to an introduction to Emeritus Professor Tony Blackshield, AO. He is our guest of honour at this annual eponymous lecture, an accomplished, respected and popular academic and legal scholar. Tony first made his mark at his alma mater, the University of Sydney, in the early 60s, where his students included former High Court Justice Michael Kirby, who we're honoured to have here tonight, and similarly eminent contemporaries such as Murray Gleeson, David Hodgson, Graham Hill, Jane Matthews, Brian Tamberlin and many others. Recognising both his scholarship and his teaching capabilities, Hal Wooten chose him as one of the legendary Magnificent Seven to lead the establishment of the University of New South Wales Law School in the early 70s. And from the late 70s until the late 80s, he was Professor of Legal Studies at La Trobe University in Victoria, where he had the opportunity to teach and study the law from a whole new set of viewpoints by teaching law to non-lawyers. His time at La Trobe was incredibly fruitful in many other ways as well, as it was during that time that he became a well-known legal public intellectual, researching and providing serious commentary on the law and its institutions. As an aside, it was also during this time in Victoria that he got to know a brilliant young academic at Melbourne, who would blaze a distinguished trail that has culminated in her being our guest speaker tonight. However, in terms of scholarship and teaching and ongoing legacy, it could be argued that it was his time at the Macquarie Law School from the 1988 until the late 90s has had the most profound, if you like, whole-of-school impact on the Australian legal academic scene. His teaching style that balanced an unflinching academic rigour with anecdote, context, and sometimes song has galvanised and inspired a whole new generation of leaders, including Professor George Williams AO, a previous Blackshield speaker, and doubtless many of you here tonight. Finally, and most significantly, it's fitting that we acknowledge his formal contributions to legal philosophy and constitutional law scholarship, both here at Macquarie and elsewhere. His influence is both historic, but also very much a living legacy that's part of the law school's current day identity. This legacy continues at the highest levels of Australia's legal, academic and civic landscape, and allows me now to loop back to the brilliant young academic at Melbourne during Tony's La Trobe years, who is tonight's distinguished guest speaker. We are indeed very honoured to welcome the President of the Australian Human Rights Commission, Emeritus Professor Gillian Triggs, here tonight. Gillian is a long-term colleague of Tony, and I understand considers him to be one of her key mentors. Renowned for her accomplishments and scholarship in international and human rights law, prior to her appointment to the Human Rights Commission in 2012, Gillian was Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney from 2007 to 2012. She was Director of the British Institute of International and Comparative Law 2005 to 7. She's a former barrister with 7 Wentworth Chambers and a Governor of the College of Law. Her commitment to legal education and to human rights law, with a particular focus on the rights of children, means that she is well placed as tonight's speaker, as part of a series that aims to continue Tony Blackshield's legacy by engaging with public law issues of fundamental importance, just as Tony has always encouraged in his teaching, his scholarship and his songs. So I trust you will enjoy tonight's lecture on human rights and the overreach of executive discretion, citizenship, asylum seekers and whistleblowers. And it gives me very great pleasure to hand over to Emeritus Professor Gillian Triggs.
Thank you very much, Professor Wilkinson. And may I also, in this wonderful federal court, acknowledge the traditional owners of the land and the Gadigal people, and respect their elders past and present. Well, it's been, of course, a very special pleasure for me to speak in honour of Professor Blackshield, who, as has been pointed out, has been a long-time colleague of mine since, I think, the 60s or early 70s. Professor Blackshield is a constitutional law scholar of the highest order and one of the most influential figures in Australian legal education for over 50 years. And I've got 2 special memories of Professor Blackshield. One is that he was, of course, a lecturer without peer. I used, as a young academic, to go to some of his lectures, never having any particular interest in the Constitution, as may very well become evident when you hear my lecture. But nonetheless, I would go because I knew that this was a man who really knew not only his subject, but knew how to engage the students. And I have fond memories of you going up and down the aisle between the lecture, in that terrible old lecture theatre at Melbourne University, but completely absorbing the students. in every word that you said, and challenging them for their views and challenging them to read the cases, all very provocative with a superb knowledge of constitutional law and the common law. And then when I was Dean of the Sydney Law School, I was oft to be found showing off that beautiful crystal palace of a law school. And one day I found Professor Blackshield buried in books in the library on a general desk with all the students. As such a modest man, he wouldn't have dreamt of coming up to my office and saying, could he have a special desk or a special office? He just simply came in and did his work like anybody else. So I think it's been a great privilege for me to have known him and to watched his work, and for me to have learned a little about how to communicate with students and how to reach that, how to understand the cases and to talk about them. Well, it was also typical, of course, of Professor Blackshield that when discussing the topic for tonight's lecture, he observed that this is the 5th of November, the 410th anniversary of the gunpowder plot in London in 1605, so called because of the attempt by the Catholic Guy Fawkes and others to blow up the Houses of Parliament and to kill the Protestant King James I. While such violent intentions can hardly be condoned, especially by me, my theme tonight also challenges Australia's parliaments by observing that they have, over the last few years, passed laws that explicitly or in their effect breach fundamental human rights. Not only have our parliaments failed to exercise their traditional restraint to protect our common law freedoms and liberties, but also they've allowed executive governments to expand discretionary powers and increasingly to exclude the courts and judges from exercising judicial scrutiny or control. The doctrine of separation of powers is all too often ignored by Parliament, and the rule of law and international law and Australia's obligations under human rights treaties are often trumped by the government's uncontested assessment of national interest and security. For the Australian Human Rights Commission, this has been a year of living dangerously, as we've drawn attention to the erosion of our human rights and to the diminution of the checks and balances that preserve our democracy, all in a year in which, ironically, we also celebrate the 800th anniversary of the Magna Carta and the 70th anniversary of the United Nations Charter and the creation of the Nuremberg Tribunal for Crimes Against Humanity. Magna Carta was at its heart an attempt by the feudal barons to constrain the power of bad King John and to ensure that the sovereign is subject to the rule of law, in particular to the common law, and to an independent judicial scrutiny. But let us fast forward from 1215 to a few weeks ago, an Operation Fortitude. How could this happen? Operation Fortitude provides a very powerful example of the executive overreach in civilian affairs. You will recall that the recently merged Department of Immigration and Border Protection announced Operation Fortitude, under which what I call a coalition of the willing, including the Victoria Police, Yarra Trams, Metro Trains, the Sheriff's Office, Taxi Services Commission and the Australian Border Force, agreed to target crimes ranging from antisocial behaviour to outstanding warrants of arrest. The now notorious media release states that the intention was to position Border Force officers at, and I quote, various locations around the Melbourne CBD, speaking with any individual we cross paths with. The focus of this strategy was revealed by the warning, if you commit visa fraud, you know it's only a matter of time before you're caught. It's true that many people in the Australian community do not have a valid visa or have overstayed their visas. It's also true that a nation has a sovereign right to arrest and deport those who are in Australia illegally. Indeed, the AFP, police and other law enforcement agencies do so regularly, if quietly, under Section 188 of the Migration Act, where there is probable cause to stop them and question them. But never before have we had Australian Border Force officers planning to stop people in shopping malls demanding identification. Quite apart from the legal fact that the Border Force do not have the power to do so, it's a reasonable assumption that those chosen for questioning will be those that fit a racial profile, contrary to the Racial Discrimination Act. I don't think as I walk down the Bourke Street Mall with my pearl earrings and my little jacket that they're going to stop me and ask me for my visa or for any authorisation. So I think the point was really very powerfully made. But you know, of course, that Melburnians reacted to the media release by demonstrating on the streets of Flinders Street Station, gathered together by social media, They blocked the traffic for some hours, but very shortly after, Operation Fortitude had been cancelled and all concerned ran for cover, blaming low-level officials. Well, Operation Fortitude raises many questions. My question is, how is it that public officials within the Border Protection Department, the Australian Federal Police and the Victorian Police and other agencies, whether senior or not, did not ask whether such a paramilitary operation was consistent with Australian liberties? Are we as a nation, and are our government officials so ill-informed about human rights under the Constitution, the common law and international law, that no one thought to question so obvious a violation of our freedoms to walk the streets without fear of being stopped and questioned? Operation Fortitude is but one example of the tendency to increase executive power, and indeed to criminalise behaviour that in the past might have attracted a civil fine. Australian governments have introduced and parliaments have passed scores of laws that infringe our common law freedoms of speech, of association and movement, the right to a fair trial, and the prohibition on arbitrary detention. These new laws undermine a healthy and robust democracy, especially when they grant discretionary powers to executive governments in the absence of meaningful judicial scrutiny. And I think the United States President Woodrow Wilson is quite correct when he says, liberty has never come from the government. Liberty has always come from the subjects of government. The history of liberty is the history of the limitation of government, not the increase of it. Well, what explains Australia's move to such restrictive approaches? And I'd suggest that there's a conflation in the public mind of the events of 2001. The Tampa crisis on the 26th of August, the children overboard misstatements of the 6th of October, and a month later, you'll recall, 9/11 terrorist attacks on the United States. Since these events 14 years ago, governments and political leaders have played on community fears of terrorism and the unauthorised entry of refugees to concentrate power in the hands of the executive to the detriment of Australian liberty. Well, this evening I'd like to discuss the overreach of executive discretion and to look at the role of parliaments, because particularly troubling, I think, has been the phenomenon of the major political parties agreeing with each other to pass laws that threaten our freedoms. Indeed, respective governments have been remarkably successful in persuading Parliament to pass laws that are contrary, even explicitly contrary, to our common law rights and to the international human rights regime to which Australia is a party. There are many examples, and of course I can't go through them tonight, but I might mention the counterterrorism laws, the retention of data, metadata, and critically the access to that data by law enforcement agencies without a warrant and without any independent or judicial authorisation or oversight. Now, if you contrast that to access to content to data, emails, though that content must be accessed only with a warrant. And yet, curiously, you can learn a great deal more from metadata than you can from the content of a single email. We have the criminalisation of Australians who enter declared areas in Syria and Iran, placing the burden of proving a legitimate reason on the accused. We have the cancellation of visas and mandatory detention of those who've become unlawful non-citizens, for example, by failing the character test, a test that depends on the minister's suspicion that even minor offences have occurred. All this coupled with the power of the minister to overturn any subsequent decision of the Administrative Appeals Tribunal. We have lengthy administrative detention of the mentally ill or unfit to plead without trial. We have significant levels of secrecy for Operation Sovereign Borders and on-water activities, or the recent secrecy laws under the Australian Border Force Act passed this year that criminalises all immigration workers, consultants and service providers who disclose protected information, an offence that attracts a penalty of 2 years' imprisonment. And we also have, and less obvious, is the legislative exclusion from the Administrative Decisions Review Act of all decisions relating to counterterrorism, national security and migration laws. So we've excluded the judiciary from considering those kinds of matters. Well, the legislation that I've very briefly listed has been assented to by parliaments, an obvious but vital point, but it raises for me the question of the proper limits on the power of Parliament. What are the safeguards of democratic liberties if Parliament itself is complicit in expanding executive power to the detriment of the judiciary and ultimately of all Australian citizens? What are the options for democracy when both major parties in government and opposition agree on laws that violate our freedoms and treaties? Well, I don't have a full answer to that, but I would like to explain why it is that Australia has become increasingly isolationist and exceptional in its approach to the protection of human rights. I think you will all know that our Constitution does protect some freedoms: the freedom of religion, the right to compensation for the acquisition of property, the right to vote, and the right to trial by jury. And the High Court implies a right of political communications. But that's all. As is also well known, unlike every other common law country in the world, and of course most civil law countries, Australia has no charter or Bill of Rights. This means that we do not have the core benchmarks against which to measure or challenge laws that breach fundamental freedoms. It's notable, by way of example, that the United States Supreme Court can employ the jurisprudence of the 14th Amendment on equality before the law to decide that marriage is available to all people, including those of the same sex. Despite what I've said about this extraordinary situation in which we have few constitutional provisions and no legislated Bill or Charter of Rights, it remains true that, for the most part, Australia has been a good international citizen. We've played an active role in negotiating the human rights treaties that form the international monitoring regime. And we all know, of course, Doc Everett and his role with the UN Charter itself, and invited by Eleanor Roosevelt as one of 8 countries to work on the Universal Declaration of Human Rights. And since that time, Australia has been a major player. We've been drafting the treaties, we've been supporting them politically, and almost invariably ratifying those treaties. But the lamentable fact is that the key human rights treaties that have been developed since particularly 1948, such as the International Covenant on Civil and Political Rights, the Covenant on Economic, Social and Cultural Rights, and the Convention on the Rights of the Child, are not implemented into domestic law and therefore not directly available to our courts. There are, of course, 3 important exceptions: the Conventions on Discrimination on the grounds of race and sex and disability, where that legislation underpins the work of the Australian Human Rights Commission. But not only are the core human rights instruments not part of Australian law, but over the last few months we've actually taken some backward steps of stripping international law from our domestic law in those relatively few cases in which those laws have existed. One, in the Maritime Powers Act late last year, has stripped out references to the Refugee Convention, and the terms refugee or well-founded fear of persecution are now matters for determination according to the words of the statute and Australian law, but not by reference to international law. Especially worrying are the changes for the Australian Border Force Act, which provides that officers have a duty to remove, as soon as is reasonably practical, those who are unlawful non-citizens, and they have that obligation regardless of any breach of Australia's non-refoulement obligations under international law. It is also not a matter you cannot challenge an officer for carrying out their activities under the Border Force Act where natural justice has not been satisfied or where there's been some other breach of international law. It's notable too that that act in particular slipped through the House of Representatives in March this year without a single opposition party speaking against it. Only 2 spoke in relation to that in the Senate. Well, compounding what I think is our growing isolation from international human rights jurisprudence is the fact that the Asia-Pacific region has no regional human rights treaty and no regional commission or court to develop human rights law or to build a consensus, unlike Europe, North America, Africa, Latin America, and more recently, the Arab states. And I think that has meant that we have become genuinely isolated from the language of human rights, which infuses all aspects of law in most other regions of the world. Well, it might be thought, having painted a rather gloomy picture, that we could rely on our courts to protect common law liberties. Judges have employed the principle of legality to adopt a restrictive interpretation of legislation to protect common law freedoms. Laws passed by Parliament are not to be construed as abrogating fundamental common law rights, privileges and immunities in the absence of clear words or unmistakable and unambiguous language. It's also presumed that Parliament intends to act in conformity with international law. But in practice, the principle of legality and the presumption of international law consistency have not provided as effective protection as we might have hoped. There's a palpable reluctance by courts to refer to an international source of law where the international obligation or principle has not been implemented by domestic law and by Parliament. Moreover, the presumption of legality applies only if there's an ambiguity in the words of the legislation. The rationale, of course, being that Parliament's the lawmaker and the task of the courts is to interpret and implement that law. But as our laws today are drafted or amended or redrafted with such precision, ambiguities are increasingly hard for the courts to find, and therefore it's increasingly difficult to find an opportunity to apply the principle of legality. And perhaps an example is the Malaysian Declaration case in 2011, the so-called Plaintiff M70. There, the court found that Section 98A of the Migration Act meant that the minister could not send asylum seekers to Malaysia as the nation had not ratified the Refugee Convention and they'd be at risk of return to a country of persecution and discrimination. The point being that that section in the legislation had specifically required that any declaration of a country as being appropriate to send asylum seekers had to be one which complied with international law. And the court interpreted that to mean, of course, the Refugee Convention. Well, I think you all know the end of that particular story. The government immediately returned to Parliament and deleted the offending clause, so that that avenue to constrain what we did with offshore processing was cut off. The Malaysian case also illustrates the phenomenon that time and again the High Court has limited executive discretion by reference to statutory principles of interpretation and the principle of legality, but that time and again the government has been successful in asking Parliament to tighten up the legislation to permit what has hitherto been illegal. Historically, of course, Parliament has been the bulwark against the sovereign and against sovereign power. Professor George William estimates that there are currently over 350 Australian laws that infringe fundamental freedoms, and he suggests that prioritising government power has become a routine part of the legislative process, stimulating very little community or media response. A similar assessment is confirmed by the interim report of the Australian Law Reform Commission. Well, despite the disappointing failure of parliaments to protect human rights, it can be observed that Australia's historical and current preference has been to rely on its parliaments rather than courts. And one of the most important mechanisms to ensure that Australia does act consistently with international law is the recent, now relatively recent, enactment of the Human Rights Parliamentary Scrutiny Act that creates a scrutiny committee in the Commonwealth, or for the Commonwealth in Parliament, in 2011. That scrutiny committee is a very important advancement for human rights in Australia because it's the first time that every one of the 7 major international human rights treaties to which Australia is a party has formed the underlying mandate of that scrutiny committee. So it is a commitment by Parliament to the human rights principles and a willingness of the committee until relatively recently to achieve consensus reports, which, as you can imagine, is no mean feat when you've got members of all the major parties on that committee. They've nonetheless been able to agree on the core principles of human rights and how bills might affect them in one way or another. It's also, of course, a point that in many ways the common law can be reflected in international law and international law reflected in the common law. And Chief Justice French has pointed out it doesn't take a great stretch of the imagination to visualise intersections between fundamental rights and of the common law and the fundamental rights of the Universal Declaration and international conventions to which Australia is a party. Well, the Scrutiny Committee has been significant, it has a potential to be significant, but although it has frequently reported to say that various bills breach international human rights law in relation to one of those 7 treaties, sadly, its recommendations are rarely accepted by Parliament, so that it plays a role, but it's a very limited role when it comes to altering a bill that is finally passed. One example is the recent amendments to the Migration Act with regard to unauthorised maritime arrivals. The Minister for Immigration concluded that the rights to freedom of movement and to family and the right not to be detained arbitrarily and the rights of the child were not engaged because asylum seekers are unlawfully in Australia. Well, the Scrutiny Committee said, as a matter of international law, persons who are not lawfully present in Australian territory nonetheless enjoy a range of rights under the International Covenant on Civil and Political Rights. And the committee went on to expand on the rights, particularly of children and their transfer to regional processing. But that report did not persuade the government to change its mind. Well, in addition to the central role of Parliament, of course, are the powers and functions of the Australian Human Rights Commission. We're coming up to our 30th birthday, and we've survived then for nearly 30 years. We are one of 110 national human rights bodies in the world, and one of the relatively few with A status under the Paris Principles. The most important characteristics, of course, are independence from government and independence of the President and Commissioners. And we have a number of very wide-ranging functions, including dealing with the 22,000 inquiries and complaints we receive a year, but also an independent right to inquire into acts or practices that may be inconsistent with human rights. Well, critical to the role of the Commission is the definition of human rights. And again, we have the same, with one exception, the same treaties that form the basis of our definition of human rights. In particular, of course, the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. But I think you can see that this places the Commission in a rather awkward position, because we will, like the Parliamentary Scrutiny Committee, be calling attention to breaches of those treaties with government and ministers, but we are faced with the problem that the government officials and ministers can correctly say, but they're not part of Australian law, and therefore our concerns do not carry the weight that they would if they had been enacted into domestic law. So it's a little bit like ships passing in the night. We put the view, but we have a system of domestic law that does not embrace these principles other than through a parliamentary commitment through the Scrutiny Committee. Well, it's in that environment where I believe that we are drifting further and further away from the human rights jurisprudence, particularly in Europe, that I'd like to discuss two examples of what I think are executive overreach. I think you're all aware that the government has been passing tranches of new counterterrorism laws, and those laws needed to be reformed. They were rather outdated, and they failed in their traditional form to recognise that terrorism is individual and is not state-based. But I'd suggest that the strength of the rule of law is more truly tested when security is threatened than in times of peace. When Australia is threatened by terrorism, the need to protect our liberties assumes an even greater urgency. Many counter-terrorism laws, introduced with unseemly haste before Christmas, go well beyond what might be deemed to be proportionate, having a chilling effect on freedom of speech and the press and breaching the right to privacy. There's one area that I particularly wanted to mention, in addition to the foreign fighters laws, the mandatory data retention laws, is the Australian Citizenship Allegiance to Australia Bill introduced this year. This is designed to ensure that Australian citizens accused of fighting for or in the service of a declared terrorist organisation or acting inconsistently with their allegiance to Australia will be stripped of their citizenship automatically, including that of their children if they're dual nationals. The wording of the bill is ill-defined, and I don't think we've ever had to consider what acting inconsistently with allegiance to Australia actually means. But it does include the relatively minor offence of damaging Commonwealth property. I think we'll all have to think carefully about what actually is Commonwealth property. The loss of citizenship for dual nationals, including those who have spent most, if not all, of their lives in Australia, strikes at the heart of Australia's successful migrant and multicultural nation and threatens our social cohesion. Under current law, the power of the Minister to revoke citizenship arises if there's a conviction for specified offences, but it's now proposed that revocation will arise by operation of law rather than the initially proposed subjective ministerial discretion. No decision is required by the Minister, but it's implicit that an official somewhere in the system will have to make a decision based on some evidence. It's also proposed that the minister be granted a non-compellable discretion to exempt citizens from the automaticity of the loss of citizenship if the minister considers it appropriate to do so. The minister cannot be required to think about whether he'll exercise his discretion, and if he makes any mistakes, he's not bound by the rules of natural justice. Well, the Magna Carta has something to say about this. That is, no man is to be outlawed or exiled except by the law of the land. This ancient principle raises the question whether it's consistent with the rule of law for Parliament to pass legislation to withdraw citizenship automatically, subject to a discretion of the minister. I suggest that to do so is contrary to the International Covenant on Civil and Political Rights, the Article 12.4, which protects the right to enter and remain in one's own country. In effect, Parliament has elevated the subjective views of a minister above an evidence-based determination by a judge according to established rules of evidence and law. The government argues that the right to a fair trial over loss of citizenship is not threatened by the bill because there can always be judicial review of any decision made by the minister. This is true. A court could review whether the power under the Act has been exercised according to the law. But all the law requires in the statute is that the minister can exercise his discretion as he considers appropriate. In practice, the courts have nothing to review. Thus, the exercise would be basically futile. And in this way, the courts are excluded from the process other than the theoretical power to review the unreviewable. The bill, I suggest, diminishes the judicial power to make determinations and will, if passed, be an arbitrary overreach of executive discretion. Well, the second area of overreach that I wanted to mention concerns arbitrary and indefinite detention. And again, the Magna Carta has these enduring words: no free man may be imprisoned except by the lawful judgment of his equals or by the law of the land. Over recent years, respective parliaments have granted governments the power to detain indefinitely various classes of persons, most notably, of course, refugees and asylum seekers, but others less well known who have infectious diseases, who are mentally ill or unfit to plead to criminal charges, those subject to mandatory admission to drug and alcohol rehabilitation facilities, or indefinite detention of serious sex offenders or those that government considers could be a danger to society. Few of those detained under such laws have meaningful access to legal advice or regular independent judicial or administrative review. The Australian Human Rights Commission is particularly concerned by the growing instances of detention in prisons of those with cognitive disabilities for lengthy periods without releasing them into more appropriate facilities and in the absence of regular review by independent tribunals. In a recent complaint, as President, I made findings and recommendations in relation to 4 Aboriginal men with intellectual and cognitive disabilities held for many years in a maximum security prison in the Northern Territory. Each complainant had been found unfit to stand trial or found not guilty by reason of insanity. And in respect of 2 of these men, they would have received a maximum sentence of 12 months had they been duly convicted. Instead, they were imprisoned for 4.5 years and 6 years respectively. And we found that the failure by the Commonwealth was a violation of the right not to be detained arbitrarily under Article 9 of the International Covenant on Civil and Political Rights, a provision, of course, that's in the spirit of the Magna Carta. Now, I cite that example, but there are now scores of these cases emerging all over Australia, perhaps the worst of them being a young man with a cognitive disability in Western Australia who was held for more than 10 years before we found out about his case. A complaint was brought to us and we were able ultimately to have him released on conditions, subject to certain scrutiny, but at least able to live in community housing and to rebuild his life. Detention powers of the executive have also been expanded to detain asylum seekers and refugees indefinitely, powers that were found to be valid by the High Court, of course, as you all know, in the Al-Khatib case in 2007. Most egregiously, those with ASIO adverse security assessments are detained indefinitely, including children. Some of them I visit in Villawood have been held for some years without meaningful access to independent review. This year, we have exactly 2,044 people in closed detention in Australia, 113 of them are children. We have 934 males remaining in indefinite detention on Manus Island, and 631 refugees on Nauru, including 92 children. Most of these people have been held for well over a year in conditions that have been criticised by the United Nations as breaching the Torture Convention. The mandatory detention provisions of the Migration Act have also been somewhat surprisingly activated by the Section 501 provisions of the Migrations Amendment, Character and General Visa Cancellation Act, passed late last year, that allows the minister to cancel visas on character grounds on the basis of his reasonable suspicion that a person doesn't pass the character test. That amounts to any possible risk of committing certain offences, including disruptive activities or inciting discord in the community. Over the last 3 months, over 200 visas have been cancelled. This is 8 times the usual number over the last 3 to 4 years. And it includes over 100 New Zealanders who are being picked up and detained now on Christmas Island for deportation on the cancellation of their visas for character reasons. While earlier law required a criminal conviction by a court of law, the new provisions give the minister personal, non-delegable, non-compellable and non-merits review powers to cancel those visas. The Australian Human Rights Commission has expressed our concerns that these powers increase the likelihood of arbitrary detention and unjustified interference with the families and the rights of the children. Even more worrying, the minister has the power to overturn a decision of the Administrative Appeals Tribunal that revokes a decision to cancel a visa, and there is no need to satisfy the principles of natural justice. Well, that's a very gloomy picture, I think, and it can be developed 20 times over in legislation introduced in the last few years. But there are some very encouraging decisions of the High Court of Australia that shine some rays of light on the unconstrained powers of Parliament to give the executive the power to detain. Last year, in Plaintiff S4, they're not very imaginative names at this level, but there it is, S4, the High Court decided unanimously that the executive decision to detain was limited to 2 purposes: deportation or a decision whether to allow the plaintiff to apply for a visa. The court qualified the power to detain, finding that the Migration Act does not authorise the detention of an asylum seeker at the unconstrained discretion of a minister. It found that an alien is not an outlaw and that the minister must make a decision one way or the other as soon as is practicable. Now, what as soon as practicable actually means will be a matter ultimately for the courts. But I do think that it will hurry up the release of people in detention in Australia. But sadly, I've been perhaps pedantically through those figures of those people we continue to detain. While the numbers are slightly declining in Australia, they're going up in Nauru. And the numbers this month are higher than they were the month before, and we're seeing increasing numbers going to that island. There's another decision which was followed by was followed by the High Court issuing, very rarely, a writ of mandamus against the Minister for Immigration in the plaintiff S97, in which last year the court again unanimously confirmed that writ of mandamus was properly issued by the Chief Justice, and it ordered the minister to comply with his statutory obligations by deciding either to grant a visa to a refugee held in closed detention for 3 years or to deport him. In other words, the High Court is attempting to insist, through principles of statutory interpretation, that we cannot hold people indefinitely. A decision must be made, and where they are stateless or where the state of which they have nationality will not receive them, then a decision must be made to release them, at least into community detention, where they can be watched if they are thought to be of danger to the society. But I'd suggest that the level of administrative detention, particularly in relation to refugees and asylum seekers, has become punitive, and that, as we know, is a power of the courts alone. I suggest that the prolonged and indefinite administrative detention is becoming punitive and violates the principle of the separation of powers. Now, there's one other aspect that I haven't mentioned, and that is that international human rights law is enforced to a degree by the United Nations monitoring processes through the Human Rights Council and the Human Rights Committee. Both of these institutions have been clear in voicing their concerns about the legality of detention and offshore processing, as also have the High Commissioner for Human Rights, the High Commissioner for Refugees, the Subcommittee on Torture, whose concerns about the conditions on Nauru received a response from the Australian government that we did not want to be lectured by the United Nations. The Special Rapporteur on Migration has cancelled his visit to Nauru because of the secrecy laws under which, as I've said, service providers could be penalised with 2 years imprisonment. And of course, very strong and well evidenced and documented work of civil society, Amnesty International, Human Rights Watch, the Council for Human Rights, the Refugee Advice and Casework Service, the Calder Centre, and many others. Well, shortly I leave for Geneva for the Universal Periodic Review process by the United Nations Human Rights Council next Monday afternoon. Concerns of the international community in respect of the mandatory detention and offshore processing policies will almost certainly be expressed at that meeting, and I think the outcome may well affect the strength and credibility of Australia's bid for a seat on the Human Rights Council in 2018 to 20. I do believe that Australia deserves a seat on the Human Rights Council if you look at our long-standing commitment to international human rights and the contribution that we've made to it. But I think it will be a matter of explanation for the policies that we've adopted over the last few years. So in conclusion, one of the many lessons that I've learned over my 3 years as President of the Commission is that one of the most effective safeguards of human rights is the cultural expectation of Australians that our freedoms will be protected. While most Australians are highly unlikely to be able to describe the doctrine of the separation of powers, they're quick to assert their liberties under the rubric of a fair go, a phrase that I think is as close to a Bill of Rights in this country as we're likely to get, at least in the short term. But it's that cultural expectation that keeps our freedoms alive today, as was illustrated by the overwhelming community response to Operation Fortitude, and of course to the strong community efforts to preserve Section 18C of the Racial Discrimination Act, an act, of course, we celebrate its 40th anniversary this year. The scores of laws passed recently that infringe our rights has confirmed my view that Australia needs to reignite the discussion about some form of legislated Charter of Rights. If such a law were to fail or be defective, it can be repealed or amended. I think it's a national priority to promote the education of young Australians so that they better understand constitutional protections for democracy and the rule of law, but they also understand the international legal system and the principles of international human rights law. And I believe we need to invest in Parliament as a vital institution to protect our rights and freedoms through education, even of our parliamentarians. And I think we need stronger powers for the Parliamentary Scrutiny Committee to insist that its recommendations are taken fully into account by Parliament. So finally, I hope that despite challenging the powers of Parliament and the Executive, as an English migrant and a dual citizen, I hope to keep my Australian passport and eventually retire to smell the roses. Thank you very much.
Thank you very much, Gillian. And now my pleasure to introduce Professor Tony Blackshield for his response.
Thank you, Natalie. Well, given the subject matter of tonight's lecture, it was predictable that it was going to be sobering, and given the speaker, it was predictable that it was going to be inspiring, and it's been both those things, and we thank you for it enormously. I have so much to thank Gillian for. She's been an inspiration to me for many years, but never more than in the last couple of years when she's been subjected to an incredible barrage of criticism from people who should have known better. And she stuck to her guns not only with tenacity, That's exactly, that applause is exactly what I wanted to say. I see in tonight's news that George Brandis has been extremely protective of the human rights of Tony Abbott. And I only wish that he'd been similarly protective of the human rights of Gillian Triggs. Gillian was criticised for having singled out the Abbott government for special criticism. And of course she did no such thing. It's often said that anything that people might have objected to under the Howard government was only a logical continuation of tendencies that had begun under Hawke and Keating, and that's obviously true in this area. The first shot across the bows in the war on refugees was the Migration Reform Act, the Migration Amendment Act of 1992, aimed specifically at 2 boatloads of refugees and making special laws to take away the legal rights of 35 identified people referred to in the Act as the designated persons. It included, for example, the provision which the High Court actually struck down in the Chu Cheng Lim case. A court is not to order the release from custody of a designated person. Introducing that law in 1992 was the Immigration Minister of the time, Jerry Hand, and in introducing it he said this, he said, "The government has no wish to keep people in custody indefinitely, and I could not expect the Parliament to support such a suggestion." And yet 6 months later he introduced the Migration Reform Act, which later in the Al-Khatib case was held to have exactly that effect. We all know that things did get worse under Howard, although I have to say I thought they got marginally better when Amanda Vanstone was Immigration Minister. They got marginally better again under Rudd number 1. Under Gillard they got worse than they had ever been under Howard. Under Rudd number 2 they got worse than they had ever been under Gillard. And all of that was only laying the foundation for what happened with Abbott and Morrison. And the point of that history is that it's been an inexorable escalation in which both sides of politics are equally to blame. And because the dead weight of that history is now so great, it's going to be terribly, terribly difficult to reverse that process, but sooner or later somebody's got to. It's a great pleasure to me to see so many graduates from Macquarie Law School here tonight, especially the ones that I taught in the 1990s that I must say I feel a special sentimentality and nostalgia for. But I also see, as well as those people who I taught at Macquarie 20 years ago, I see people that I taught at New South Wales 40 years ago, and people that I taught at Sydney 50 years ago and more. And among them, as David has already pointed out, is Michael Kirby, and it's so lovely to see him sitting here. The very first class I ever taught included Michael Kirby and Murray Gleeson, and I've always said they were 2 of the best students I've ever taught. I saw a lot more of Michael when I was at Macquarie, because when I arrived he was University Chancellor, and as the 90s went on he was a frequent guest at law school functions, including the series of annual dinners that we had when we would celebrate the anniversary of some famous case and I would compose a song about the case. And Michael was always very generous, or perhaps just very polite, in his praise of those songs, and he suggested that I might sing one tonight. I initially thought I hadn't got anything suitable, but it happened that earlier this year Rosemary and I were in Scotland, and I made a pilgrimage to Paisley to visit the site of Mincella's Cafe, where in 1928 Mrs. Donahue had her famous encounter with the snail in the ginger beer bottle. The cafe isn't there anymore, it's a vacant lot in front of a funeral parlour. But in 1990, some Canadian lawyers held the Paisley Conference on the Law of Negligence, and they installed a commemorative plaque. And 25 years later, that plaque itself is barely legible, but the local council has put up a new and much grander plaque, and it's well worth a visit. Anyhow, it reminded me of two occasions when I've had to celebrate Donahue and Stevenson. The first was when I was teaching at La Trobe. In 1982, we had a party to celebrate the 50th anniversary of Donahue and Stevenson, and we served snails and ginger beer. We had a tutor at the time called Julie Dodds, later a colleague of Gillian's at Melbourne, and later still Justice Julie Dodds Streeton of the Federal Court. And Julie prepared a delicious French sauce for the snails, and they were a great success. But the ginger beer was a disaster. I had bought 15 cases of the stuff, and none of the students drank it. They all brought along their little cardboard casks of wine, and I was drinking up ginger beer for months afterwards, and I never want to see the stuff again. The second occasion, on that occasion, we invited Lionel Murphy to propose the toast of Donahue and Stevenson, and he had a look at the case before he came. For all I know, he only got as far as the first page, but he noticed that Mrs. Donahue was suing informa pauperis. And so he devoted his speech to what a disgraceful primitive form of legal aid that was, compared with the much better form that had been introduced when he was Attorney General. And of course that was true, and it's a pity that it's not still true, and that's another thing that politicians of both parties have to take the blame for. Anyhow, I come to the more recent thing because 10 years later, in 1992, we had one of those dinners at Macquarie for Donahue and Stevenson, and Michael will remember this one well. And I didn't actually compose a song on that occasion, but I did take the crucial sentence from Lord Atkin's speech and set it to a theme from Schubert's Ninth Symphony. Lord Atkin asked, "Who then in law is my neighbour?" And the answer was this: "The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions that are called in question." So closely and directly affected by my acts that I ought reasonably to have them in contemplation. Just apply that to a government minister making policy for refugees.
But I know it's too great an opportunity to pass up, so if there's a couple of questions we could potentially take for either Tony or Gillian.
Yes. Questions, and if you're going to ask a question, could you come up to this microphone here, or if you happen to be upstairs, I think there might be going to be a roving microphone. Yes, come forward, please.
Yeah, well, first, thanks to Gillian and Tony. It was a sobering but also insightful lecture. And my question is, at law school we're taught about, we have a common law system which is modified by statute. Do you think the time of common law is starting to pass in that we now have a legal system that's becoming increasingly codified? And out of that, do you think the common law will continue to be relevant into the future?
These are questions for Gillian. I may have a word too.
Good, I hope you do. Well, I think that really is one of the underlying points of what I was trying to say, that we are so dominated by statute law that is so precisely drafted now that there's so little opportunity for the common law to be introduced. And I think the question really is going to be the question I posed at the beginning: is there in the end a limit to the power of Parliament? Can the courts say Parliament simply cannot pass laws that breach what you might say are the broad principles of legality in the common law? And I hope that we'll find the courts will increasingly do that. I mean, at the moment, and the two cases I gave you right at the end are an example of the courts using, in that case, the writ of mandamus, which is so rarely used, or by taking a very strict interpretation of the legislation to say you can't have it both ways. You do one or the other, but you can't detain forever. And I'd wished I'd known that earlier quotation from earlier 92. It's very, very interesting. Yeah. So I'm eternally optimistic, and I think the common law is the great strength of our legal system. And I think it's a great pity that we're so dominated by so much overly elaborate statute law, when really core principles of the common law can actually get us there, and a much better sense of justice and fairness than we're currently achieving.
Yes, I agree. I said earlier that I was teaching Michael Kirby in 1961, but I was studying law myself in 1954, so I belong to a generation that was very good at common law reasoning, but we never really learnt to read statutes. And increasingly it's the other way round, and the common law method of reasoning and the principles that lie behind it has less and less opportunity, more and more strangulated by statute, and I think that's a great pity. And one of the questions that's been submitted from someone who wasn't able to be here tonight is from my colleague George Williams. I'm looking at the... Yes, my colleague George Williams, who asks, is it time to reinvigorate Tony Blackshield's push for a National Bill of Rights from the 1980s? And Gillian, I think, has already given her answer, but I agree, as usual, with her answer. I think yes, it is time to reinvigorate it. Back in the 1983, we did propose a Bill of Rights which would be judicially enforceable. That's one of the things you have to choose. And our proposal was to introduce it at a statutory level, but with a view that after it had been run for maybe 10 years and the judiciary had got it wrong and Parliament had had ample opportunity to correct it, eventually, once everybody was happy with it, it should be written into the Constitution. And that's still my ideal. I'm going to ask Gillian to speak in a minute. Gillian, Bill of Rights, please.
Well, thank you, Tony. I don't have any friends in the Immigration Department, I'm afraid. Unfortunately. Yes, I think that... I mean, this has been the law school question for years, hasn't it? We've always debated it. We've had students moot the question of a Bill of Rights. What would the effect be on Australian law? And there are some credible arguments put up against it. But I think my experience in the last 3 years has really confirmed to me that we really need a Bill of Rights now, when we see this drift that we've seen in the last 10 years. And when my colleagues in particularly in Europe or in the UN system, they often say to me, why is Australia so exceptional? What is it that's different about Australia from anywhere else in the world? And I think partly it is our isolation. But also I think there's a deeply ingrained distrust for the judiciary in Australia, which senior politicians have consolidated and reiterate. And I think that's extremely dangerous for our democracy, that there is a sense, and a growing sense, that if you've won government, then you're able to do whatever you want to do, and you can control the numbers in Parliament. I don't think that we're sufficiently well educated in Australia about the Constitution, about that marvel of the common law that I too was really educated in. I don't really know how to read statutes either, but that is, I think, is the core problem, that we don't educate our young people in civics, if you want to call it that. They don't understand the Constitution. In fact, I think George Williams has done some research, and I think he asked Australians in the sample, do we have a Constitution? And about 60% said no. And then he said, do we have a Bill of Rights? And about 80% said yes. And there's also that wonderful story of the man who was arrested a few months ago in Queensland for murdering his wife, and on being arrested by the police said he wanted to take the Fifth Amendment. We have no idea about our own law and how it works, and I think the failure to educate has led to a failure to understand the role of the judiciary as part of the balance within our three compartmentalised approach to democracy. So I think the failure to educate is leading to a failure to understand what our democracy is based on, and that has in turn led to a scepticism about judicial creativity, and many politicians will put that argument around quite frequently, and indeed even recently openly criticise our courts and judgments. And I think that we need a much stronger level of support at the political level for the underpinning elements of our democracy. So, yes, we do need a Bill of Rights.
Yes, yes. I'll call for one more question from the floor, but while somebody is coming forward, I'll ask Gillian to answer another of these questions. Which one would you like? You pick it, I'll read it.
No, I dare not do that. I dare not do that one.
That one?
Yes.
All right. Gillian, are there any legal impediments to the proposed changes to citizenship laws that would strip passports from those going overseas to Asia Minor to fight in the conflict zones?
Look, thank you for that question. I think the legal answer is that this puts the creation of the law and the determination of the law all in the hands of the minister, or probably a low-level departmental official somewhere, and therefore that breaches, in my view, the separation of powers. So that's one of the arguments that I would make. The other is that you simply cannot... as you know, the legal principle is the measure necessary and proportionate to achieve a legitimate outcome? And I think it would fail that test. It's not proportionate to the legitimate outcome. And it's the other final point is really the absolute need for judicial scrutiny. But I might read out the other question because I'm not going to answer it. This is from Hilary Kincaid. She's a solicitor from Inner City Legal Centre. If I were the Chief Justice of the High Court and could pick your dream bench, a sort of judicial version of fantasy football, who would they be? Well, I knew that question was there, and I've got an answer, but I'm not telling you until I finish this job. I dare not. It'll get me into far too much trouble.
Oh dear.
I'll tell you somebody I would have loved to have on my ideal High Court, and that would be Tom Bingham from England, Lord Bingham, who was the most wonderful judge and beautifully integrated international law principles into domestic law and managed to understand. So he spoke and gave his judgments in such beautiful English, clear language, no pomposity, clear language, clear principles, and he released Irish so-called terrorists who were proven not to have been guilty and did all sorts of wonderful things. So that would be my favourite judge, but I'm not going to say anything more until I'm finished. Thank you very much.
All right, my first choice would be Isaac Isaacs. You can even see me on YouTube doing an impersonation of him. I suppose you would have to include Dixon and Kitto and Fullagar. Actually, my favourite of the three is Fullagar, but they're undoubtedly a significant package. Victor Windeyer, Ninian Stephen, Bill Dean, and I've already got to 7 and I haven't included Michael Kirby. So we'll have to squeeze him in somehow. And I would like to squeeze in Lionel Murphy. It would be disastrous to have a court consisting of 7 Lionel Murphys, but every court needs one of them. Was there another question from the floor? Because very good.
This is a question to both professors. Professor Triggs, during your speech you mentioned the community cultural expectations of a fair go. And you mentioned the 3 branches of government, the legislature, the executive and the judiciary, each of which are populated in large part by members of the legal profession. Do you think the legal profession has the same cultural expectations of a fair go, or that it's lesser, and do you think that's part of the problem?
That's an intriguing, but I think a fair question, because you would have to ask, has the legal profession really done what it can in the general community to explain what a fair go means, what the common law means, how our government operates in a democratic system. So I think maybe we have taken their support for granted, and we could have worked harder to work with the general community. But if I can say this from the height of my many years now, I really am impressed by the younger generation in the profession. In my day, I did my law degree in the early 60s. If you wanted to go to into practice, you would become, you might be a top end of the town banking finance lawyer. The idea that you would also do human rights or be interested in international law was zero. I mean, you chose your path, you went down that path, and you really didn't engage in social justice issues. By today, what students are doing is, and young lawyers, is integrating a social justice ethos and practice as part of their professional life. So they could still be the great banking finance lawyer or corporate commercial, intellectual property, whatever it is, but they, at the same time, they have a social justice component to their professional practice. And many of them are working in legal aid or they're working in community centres, and I think that's been a huge advance on my own years in the profession in the 60s, the 70s and 80s. So, but I do think that responsibility is there, and your question's a very good one. Thank you.
Well, it's my absolute pleasure to have been here this evening on a 4th highly memorable Blackshield lecture. We have been so fortunate in the speakers that we have had. Certainly setting the tone from the outset was Michael Kirby with the first one, and Gillian, you have more than lived up to expectations this evening. So thank you all very much for coming along this evening, and in extending thanks, I also wanted to acknowledge the wonderful premises that we've been able to use this evening for the Blackshield lecture. Previously we've been holding these out at the university, and it was great to have the opportunity to come in and use the Federal Court. So my thanks in his absence to President Alsop, and also to Mr. Warwick Soden, who's a Macquarie Law School alumnus who facilitated us using this venue tonight, and to his team that worked with us in all the preparation. And also I'd like to acknowledge all the very hard work of Andrea Besnard and others in the Alumni office for pulling together this event, which hopefully has brought a happy balance between a key idea of the Blackshield lecture in terms of bringing the Macquarie Law School community together and having an opportunity for us to enjoy as staff, students, and former students what it means to be part of Macquarie Law School, and also to have that intellectual stimulation that is synonymous with the name Tony Blackshield. So my warmest thanks to our speakers this evening, and also to all of you for attending. And please, I hope you can join us downstairs for some drinks and canapes to continue the intellectual discussion as well as the strong sense of community. So thank you all for coming this evening.